I have a lot of questions, but I do believe that we should invite people here to ask their questions before I pitch in my own questions. And if I see any shyness, I'm going to name in particular, I see Steve Merrill was here. You know, he kind of prompted your, Alan Beatty. I know Claude Barfield have questions. Can I get any of you folk to rise to the occasion and ask a question or give a comment? Keep it short. Once we get it rolling, it will roll fast. Yeah, please. Introduce yourself, please, and there's a traveling mic.
Brian Cahan, CCIA and MIT. My question concerns, are we thinking about intellectual property too much along a spectrum of developed to undeveloped countries? And doesn't China really change the game in thinking about this? Particularly when you recall, as you pointed out, the territorial nature of intellectual property, and particularly patents, because the state plays such a strong role in patents that it doesn't play in copyright, for example. So aren't we seeing, and you can see this maybe reflected in the China's indigenous innovation policy, strategic behavior at the state level that we haven't seen before? And I'm thinking of this particularly in terms of China's use of utility model patents and the fact that they issue 20 times as many design patents each year as the US. And more generally, we have a very limited understanding of the role of state subsidies in intellectual property, particularly in patents, and also the emergence of state sovereign patent funds and investments in hedge funds or other forms of private entities that invest in patent markets strategically.
Is this still on? No, it is? Okay, thank you. Well, thanks, Brian. Those are all very big questions, and I don't think there's any question that China is acting in a strategic way, at least trying to act in a strategic way with respect to the whole interplay between standards and intellectual property and procurement policy and others that you could mention there. So there is a fairly lengthy discussion of that question in the book. I don't think they've been terribly successful so far, but they're not cowed by an absence of progress there. So I think they're going to continue doing this, and it's going to be a difficult question for not just the system to try to figure out, but the trading partners like the United States and Europe, what they actually want to do about this. So they're heavily engaged in dialogue to try to limit what damage there might be in that context. That's one way to think about it. Another way to think about it is, well, here you have a really big market that has bifurcated into a big developing country with lots of poor people who sort of still need one set of rules, if I can use that word, and then a smaller but nevertheless highly dynamic technology-oriented sector that would like a different set of rules. And China has a difficult kind of transition to make in that context. So, if you want to think about it in these terms, here's a place that's going to develop a competitive set of standards in the IT area and other areas. Is that a good thing or a bad thing? Well, I'd probably encourage the representatives of the IT industry, if they're here, or the software industry here, to sort of weigh in on that if they have any thoughts about it. But I think that's quite a difficult question. So about all you can sort of argue for, I think, is getting as much transparency out of the Chinese and other countries that are planning to do this, thinking about doing this, as you can, monitoring this as close as you can and making the right kinds of representations about trying to prevent the really strategic and damaging things. And I argue in the book for maybe the right approach here is to have very close contact on an almost continual basis at the agency level between these groups, so that in fact the Chinese know that maybe what they're trying to develop has already been developed, it's not worth their time, to actually get them sort of more integrated, linked into the standard setting system that's consistent with how we think about intellectual property. But is there anything that you can do to sort of stop the Chinese? I would think not. So I'm not sure if that's a very good answer to your question, but that's what I describe in the book.
Fred, we just started with the questions, and obviously a China question, whether it's a game changer.
You go ahead.
But let's take some more questions. Yes, please. Yeah, please.
Yeah, I'm Bruce Lehman from the International Intellectual Property Institute. And Keith, you made two statements that I thought were very important. One was that you observed that, and you had the data to show it, that we've seen a remarkable increase in the enactment of intellectual property laws throughout the world, so that virtually every country has them in place now. Of course, that's a part of the trade negotiations to a large extent of the 1990s. You also said that every, in even the poorest countries, you have a remarkable degree of human creativity. You know, that sort of sounds like a really good combination, because then we have a system where, you know, the intellectual property system is benefiting everybody. But in fact, a statistic that you really didn't discuss is that if you look at the WIPO annual report that they put out on patents, where they come from, who issues them, and so on and so forth, of all of the countries in the world that have a patent system, and that use patents, 5 jurisdictions account for over 80% of all of where all the patents originate in the world. Not where they're filed, but where they originate. In other words, inventors from 5 countries account for over 80% of the world's patents. The only country that you could call a developing country that is one of those 5 is China. But in every place else, you see, you know, a total lack of use of the patent system for domestic inventors. It's completely something for foreigners to file there. It's been my experience traveling around the world that one of the consequences of this is that there is no capacity, even in those countries, to use the patent system for people that want to. I mean, it's sort of a chicken and an egg problem. And that also morphs into the geopolitical trade development agenda area, because obviously in these countries they don't feel a stake in the patent system at all. And finally, I would just say, you know, since I work in that system quite a bit, you know, in everyday business transactions, licensing transactions, and so on in the United States, it is unbelievably complicated and complex. The sophistication, the money that goes into obtaining patents, monetizing them, is just incredible in highly developed countries, and particularly the United States. And there's this enormous gap between what goes on elsewhere. And I wonder if you would comment on that and what you think might be done about it, whether anything can be done about it, what its impact is, et cetera.
Well, I would hope that in places like the United States, that things like recent patent reform will reduce some of the transactions costs in working with the patent system. But I know that's probably not the kind of cost and sophistication you're talking about. Is that a barrier to inventors in poor countries from inventing something and patenting in the United States? I think it probably is. So what can you actually do about that? Well, I think the first thing you need to do is figure out how to get an inventive economy going in some of those poor countries, and that's, you know, inventing something that can qualify for an American utility grant, not utility model, is a rather different thing than from coming up with a story or a piece of traditional knowledge or some music. And that's the kind of creativity I think you see more often, that sometimes gets stifled in these countries because they don't have real access to the means with which to sell it. But sometimes, you know, there are costs that could be addressed even in these developing poor countries. I hope I don't irritate anybody by saying this, but in my travels through that part of the world, often the most costly barrier to local inventors to gaining local patents is the patent bar, the lawyers who, you know, are very, very protective of their system. And so they'd rather spend their time getting high rents from international inventors who want to patent in those countries than they are trying to go out and build business among the developing country inventors themselves. And you know, add that to all of the sort of problems with investment climates and not enough human capital and everything else, I think it's a tremendous restriction that will take some real effort and investment to try to deal with.
I'll pitch in a question, then I'll come to you, Patricia. You said earlier, Keith, that the IPR system had, you know, expanded quite rapidly. You had the table on that, and it did much better than the trading system in terms of liberalizing since the end of the Uruguay round. My question for you is whether, in light of that fact, we've come to the end of the notion of reciprocal negotiation for traditional IPR issues. Now, I know that goes right to the art of the TPP and other negotiations, but are we at the end of the road? And instead we should be thinking about new negotiations. I don't know how they'd be incentivized for the kind of issues you talked about, which was the public goods dimension, some kind of accessible database, those ideas. Think about that. Let me now take Patricia's question as well.
Thank you. Thanks, Gary. Patricia Sherman with Siemens. This is a comment, I guess, as much as a question, Keith. I want to compliment you, first of all, on this very impressive accomplishment. I want to pick up on your comment, and it was on your slide as well, the conundrum of finding mechanisms to increase technology transfer while sustaining innovative incentives. I guess I'm in the camp that probably is vested with the responsibility of the vigilance over sustaining innovation incentives, but we are mindful of the need to encourage not so much technology transfer, but in your comments you said diffusion. And I'd just like to say two things. First of all, I think that adding the word diffusion or deployment is critical, because business models vary, and particularly in the climate change area. If you're talking about environmentally energy efficient, environmentally sensitive technologies, you're talking about an entirely different business model where it takes more than just the transfer of technology. It takes the accompanying know-how, it takes a partnership, et cetera, to really realize an effective partnership, I guess, between the transferee of the technology and the transferor. Second of all, I want to point out that in the climate change debate, this has been taken up, not quite as gracefully or elegantly as you've posited the question, but there is a proposal for climate CTC and Ns, and I had to write it down to remind myself what that means: climate technology centers and networks. And I just want to encourage people who are concerned about these issues in the climate change space. There's a lot of work to be done there to really use this as an effective mechanism for facilitating not just the transfer but the diffusion and deployment of climate change technologies. So perhaps in one of your next fora you'll tackle that, because really the kind of work that you've done in this area would be very valuable contribution to the debate going on within the COP. Thanks.
Can I say something just briefly on that? So when I was talking about there are no apparent problems to date, or few apparent problems to date, that's really about whether you can find instances or systematic instances in which an existing patent actually prevented what would appear to be a socially beneficial transfer into a developing country. I think it's very hard to find any evidence of that kind that's really systematic. What it does seem to be lacking is on the ground ability to take these off the shelf, if you will, patented or otherwise, but important climate change technologies, and adapt them to the local economy and needs, particularly in the agricultural area where soil changes are different and soil conditions are different, and rainfall is different, and implementing climate change technology in agriculture is probably the most important part of this in much of the world. But you need to have incentives in those countries to actually do that kind of adaptive investment and research, investment and adaptation. It just doesn't work terribly well in many parts of the world. So what I actually talk about as useful interventions in the book would be trying to deal with that question through a variety of kinds of grant mechanisms that you could imagine. Sorry.
I'm going to take Claude first, and then.
There's so much here, and I've leafed through, but you may have covered this, but we just spent a number of years in the United States putting together a major reform in the patent system. Ended up with a great deal of bipartisan support, unusually. But immediately after that, or almost immediately after that, you had patent wars breaking out. You had the electronics people, high-end information, internet, and, it really hadn't done a lot for them. And we know that the legislation, we know that the calculations that are made in, say, the chemical industry about patents are different, and you may cover this in the book, than the automobile industry, and in turn that's different from the pharmaceutical industry. I guess my question is, are we close to the point where a unified system of rules for the patent, across the board patent system is breaking down, and you're going to have to move to some, and I understand the problems that this would entail, of some differentiation among sectors, just in light of what we're seeing almost immediately after we went through this exercise here in the United States?
Could you hold that? Let's take a couple more questions. This gentleman here, could you?
Hi, Ed Black, CCIA. You made some comments about the need to overall rebalance in a number of ways. I think that's important. Also talked about the need maybe for a re-examination when looking at enforcement measures of costs and benefits. Likewise, I couldn't agree more. But I wonder whether or not it also isn't very important to look at the cost and benefits of some of the basic scope and structure of IP itself, and the different regimes. If I'm not wrong, I think most of us would agree the core purpose, at least of patents and copyright, is to promote innovation and creativity. It's not primarily a property right. The property right is the tool by which innovation and creativity is promoted. So it makes sense to go back and look at a cost benefit of to what extent our tools, which in fact do limit the flow of information, which limit in a sense free speech, which limit the dissemination of knowledge, to what extent are those rules necessary to actually, in their breadth and scope, to incentivize innovation and creativity. I would just use one or two examples of whether or not we need copyright that can easily extend over 100 years. As one aberration, I think, that many of us would say is not sensible. And so restructuring core elements of the system may well be necessary. And the other factor I guess I'd throw in is you have now a global marketplace, and you have tremendous competitive pressures, which are also drivers of innovation. So to the extent that the need for IP as an undergirding incentive for innovation may well be that that's a factor, not that you get rid of it, but it may well be not necessary to have so much weight put on that factor. I mean, in my industry, I tell you, the next cell phone's not going to not get invented because of an IP right. Blocking people are going to do it because they need the market, they need to make their phone better. So the competitive drive combined with a massive marketplace to benefit from that, in some ways I think really eliminates the need for at least substantial swaths of IP protection.
Okay, I'm going to pile on with Tom Balicki's question right there, and no, right back there, and then we'll turn to you,
Great.
Keith.
First, I want to congratulate Keith. This is a tremendous achievement. I look forward to reading it more. I wanted to ask you. You talked about access to medicines and how the story has been largely positive. And I want to ask you about two elements of that story as it moves forward. The first is test data protection or data exclusivity. Arguably, you've seen a greater expansion of these rights under at least bilateral agreements than you've seen on the patent side. And I was wondering if you could comment on whether or not some of the same flexibilities that exist around patents do not exist around these rights. They're expanding further potentially in the Trans-Pacific Partnership Agreement. Is that an area where you see as a cause for concern? The second is you talked about this de facto arrangement that has evolved around HIV and some other limited disease sets, where differential pricing has largely taken care of the problem, grant making, other vehicles for addressing the need for access in lower and middle income countries. What do you see moving forward as the health conditions of the of developed and developing countries start to increasingly overlap, greater prevalence of cardiovascular disease, cancer, other conditions, where you really see a lot of the tensions happening in the Philippines, India, and China now around cancer medications? Do you see that changing this relationship at all? Is there a greater cause for concern moving forward?
Over to you.
Sorry. Okay. Well, lots of questions, so let me see what I can say about them. Although I'm reasonably confident that all of them are addressed at some level in the book, so I'm happy enough about that. So, Claude, you asked about patent reform, and then the next day, big patent wars break out, and that's still going on. Yeah, that's really an interesting phenomenon in the United States. Suggests that maybe we fixed some problems but generated other problems or missed other problems. So, for example, all of these cases that now emerge at the International Trade Commission under Section 337, which before would have been going through regular courts, are now going through an institution that probably isn't terribly well suited to try to deal with these kinds of problems. And that generates all kinds of sort of litigation that it can be damaging. So I hope we can find ways to try to
More basically about the fact that what this seems to show is that the calculations from an economist's point of view of cost benefit or from a technology person's point of view in the pharmaceutical industry relating to patents are very different. There's a lot of literature about that from chemicals, as I mentioned, or other automobile parts or whatever. And,
So,
we
yeah,
have
so-
and we have a unified system that is supposed to make the same judgments and the same calculations.
Yeah.
And is that what's the
So what I
deeper
was about to say about that is there are IP attorneys here probably will know much better than I about the sort of structural issues getting from here to there. But I think we are approaching a point where people start taking seriously the idea that there are sectoral differences in how industries depend upon intellectual property protection. I think we pretty much all agree that in the pharmaceutical biotechnology area, the cost of innovation is so large that the ability to generate those returns does require some fairly rigorous protection for a period of time. In software, the idea that you would have a 20-year period of protection for something that's going to be obsolete in a matter of months is, I can understand it legally, but as a matter of technology, policy, and economics, it's a little bit strange. So I think what you see is that markets try to work to get their own workarounds to these problems. So you get patent pools and standards organizations and many informal kinds of things. And in the microelectronics and software area, it's all about building these enormous portfolios so that if you sue me, I sue you, and then we go play golf and figure out who owes what to the other. And that's a highly inefficient way to go about innovation, it seems to me. So I think it's important for us to start taking seriously this question, but it's going to have to be done on a more integrated global scale than just having the United States go forward with something like this. If for no other reason, although I think lots of reasons, then having the weight of industries that want to see that happen globally is going to be more important than just trying to fight it out here. So I hope that does happen. In the book on this climate change thing, I do talk about some ways that you could imagine patent terms being effectively differentiated, more rapid examination periods for certain kinds of technologies that seem to have some social high benefit cost ratio to them. So you're seeing that happen at the margins, but I really do think legislative change to recognize those realities is important, and I hope is coming. Yeah, the big question in intellectual property is always, is there too much of it? Is there too little of it? There's always this balance everybody is striving for, and I am sympathetic with your question about 100-year copyright length. You know, when 2019 gets here, I imagine we'll see another copyright law in the United States that will extend somebody's patents or somebody's copyrights for another period of time. You know, economists would always argue that extending protection on something that's already been created doesn't make a lot of sense. Beyond that, it's always an empirical question. Is it too big, too strong, too long, too weak? I think in the copyrights area, the politics of protection have been so dominant that we probably have achieved an overbalance in that degree. Yeah.
But if you will, from an economic standpoint, isn't what we're really seeing from an economic standpoint in the operation of our economy, we're seeing legacy entrenched interest using the intellectual property system to block new dynamic competitive business models and players. I mean, after all, we understand that the core enforcement mechanism in intellectual property is a limited monopoly, which again, I would think most economists would say starts out with a certain presumption of negativity to it.
You could say anything about Tom's question?
Yes, let me, if that's okay, I'll turn to Tom. Yeah, I think the story so far in terms of dealing with the big three sort of type 3 issues in the developing world has been reasonably positive. We are only entering what you're talking about, which is where there's a big disease element or burden of cardiovascular diseases and lung disease and neuro problems. In the developing world, those patients will be every bit as bothered by those problems as is the case in the developed world. And there, the model of trying to get foundations to buy up things like patent rights in particular countries is not going to work terribly well. It's going to be way too expensive. And so I think we'll probably need to figure a new balance for how to deal with this problem altogether, because in the absence of some coordination, you're not going to see just Thailand, but lots of countries issuing compulsory licenses. And I think that's going to be increasingly problematic for the pharmaceutical sector as a matter of innovation. So I think it's probably time to change the terms of that discussion more sharply towards what do we do in these cases? What do we do? I'm sure you're thinking very, very hard about that, more than I am, but I think it's probably, well, we can talk about various solutions that have been raised in the past, like Jenny Lanyo's idea, which probably is a non-starter, but there are lots of ideas that can come forward in thinking about how you sort of separate innovation incentives from distribution incentives in a way that we still get enough money for generating the innovation. But that's a broad and general answer. I don't have anything very specific for you.
I'm quite mindful of the time, so let's just take one very quick round of questions. The lady with the green blouse, Steve Merrill, and this gentleman, but it has to be quick in each case. Maybe go to the mic there.
Is this mic working?
Correct.
Hi, I'm Juliana von Reffert-Bismarck from MLEX. We spoke a few weeks ago. This is actually more of a follow-up question. I'm really interested in what you were saying about the patent race and the kind of a patent bubble, and just like any other bubble, everybody hates to be the first one to burst it. So my question really is, how can you make it palatable for anybody to burst it? Whether it be, China, as everybody's talking about China, stop this patent race, or in fact the US, which is still the number one patent issuer in the world. Seems to be so many incentives to carry on innovating and to carry on looking like the world's greatest innovator, both for political and economic reasons, and on the corporate side in order to be able to sell off vast patent pools. So who should be taking the lead in this, and how can you make it palatable to anybody to be taking the lead in this, be it on the corporate side or on the government side? Thank you.
Steve?
Steve Merrill, National Academies, and if anyone is interested in the conference we're holding next week on IP and standards, see me, but that's not why I'm up here. I wanted to push you a little further on idea one, which I think it's idea one, about transparency of what exclusive rights exist and who owns them. I mean, it would seem to me, in my naivete, that if you get a government-granted exclusive right under a whole set of conditions that you have to qualify for, that there should be some obligation to disclose when you dispose of it and to whom. And one would think that in a world in which people are much more interested in making money through a variety of technology markets, there would be more interest in that proposition. And yet we also see the rise of very large patent owners that are capitalizing on the opaqueness of the system. So my question is, what is the political economy of your idea one?
Okay, this gentleman here.
Hello, my name is Ryan Myers from Toy Zone International. I was just wondering, do you think expanding and accelerating research and development tax credit in exchange for shortening the exclusive patent right will help facilitate generic version of the public good and get them out into developing countries? I don't know if policymakers have tried it already or if it's effective in terms of getting patent owners to be willing to take an accelerated R&D tax credit so they can offset all of the costs, and then they can maybe sell off their patent in a shorter time period, rather than 15, 20 years, maybe 10 years. And then you can get the patent version and it'll be cheaper, and then get out to the developing country. Is that an effective policy tool?
Quick answers, Keith.
Try to be quick here. Juliana, nice to meet you in person. How to burst the patent bubble. Politics are hard. I think the right way to do it, if I can tell you that, is for the patent offices to figure out what a real patent should be, which is to say, we define a high-quality patent as something that is truly inventive. So, pooling those resources on prior art would help a lot. Can be reduced to practice, so that's what we call the sort of utility standard. That should be raised, I think, in the United States and some other places. And is novel, right? So prior art really matters, inventiveness really matters. But in China, which is sort of following the American lead, a patent application is a good thing, full stop. And so there's not much concern about that question. And I think ultimately the only way the markets will burst this patent bubble is when the industries are fighting each other so much they realize that it's costing them more to do this, to deal with this problem, than it would be to actually go back to a system where we knew what an invention really was. So Steve, also a question on political economy. Good question. I'm sure there is money to be made in opaqueness. We know that from the American patent system itself, right? Where you actually don't necessarily have to disclose, or at least disclose in the way that would actually let everybody know what can be infringed and what isn't being infringed. I don't know what to say about the political economy of that, other than the same thing, which is, let's at least get the patent and trademark offices together to figure out what really makes sense as the bar to patenting, and what real disclosure means. In the context of doing that, I hope that they can actually convince everybody that this kind of public searchable database is going to be to their benefit on net rather than the other way around. But that's that's going to be hard. I don't doubt that. And then Brian, I guess you were asking me about things like differentiating patent terms, or maybe accelerating examination periods, or changing the fees in order to get sort of public goods technologies into the developing world more rapidly. I think there's scope for that. Absolutely. I'm not. You have to sort of figure out exactly how to do that, and it's probably going to be up to individual countries to have systems in place to do that. In the Patent and Trademark Office here, you can designate a technology you want a protection for to be a green technology, and that you're going to do things to transfer that technology more quickly and under sort of access licensing terms, and in return for that, you can get an accelerated examination period and fee differentiation, and that seems to be having some impact. So I think it's possible, but again, trying to do that in a coordinated way across the world is going to be a real challenge. But I think that's possible, but do that in conjunction with coming up with additional resources for investing in adaptation is important in my view.
Okay, I think it's time to end. Keith, thank you once again for doing such a thorough work. Thanks to all of you coming. Meeting adjourned.